In one of the introductory seminars, we argued that the European Union is a peculiar political organization. It does not fit into the standard classes we generally use. It is not an outright confederation, nor can it be considered a proper federal republic. Depending on the area of policy, the EU may function as a confederal order or a federal one. Because of its peculiar nature, we have opted to consider it a federal system. The EU stands somewhere in between a confederation and a federation. The European Union is based on a set of international treaties. These namely are 1. The Treaty on the Functioning of the European Union, or TFEU, and 2. The Treaty on European Union, or TEU. The nation-states that have signed and ratified those treaties are formally referred to as the member states of the European Union. The fact that the Union's primary law is a set of international treaties can lead one to think that it is an international organization such as, say, the United Nations. Strictly speaking, though, that inference is incorrect. Compared to such entities, the EU is much more competent in the relative power it wields. This is to be attributed to the substantive nature of European law as supranational rather than international. Unlike most international covenants, the EU treaties form a very strong bond between the participating nations. Their provisions have far-reaching ramifications for the legal institutional order of the member states. In exchange for the greater benefits of European integration, a nation-state that joins the EU must comply with an extensive legal corpus and be prepared to give up on its authority, or aspects thereof, over several areas of policy. The European treaties establish institutions above the national level that can exercise sovereign control over certain issues. For example, the European Central Bank is envisaged in the EU's primary law as one such supranational institution, and as far as monetary policy in the euro area is concerned, it is the supreme authority. Another case in point would be the ordinary legislative procedure at the European level. On several areas of policy, the European Union promulgates laws that are binding on the member states. Such legislation typically takes precedence over any national law that may contradict it. In other words, a national legislature cannot overrule the European one, if the latter enjoys primacy by virtue of rights conferred to it in the Union's primary law. It is no metaphor or exaggeration to suggest that the European treaties have a constitutional standing. Although they are still referred to as if they were typical instruments of interstate politics, their actual function is that of a codified corpus of primary law. The treaties regulate relations between the supranational and the national levels, as well as among the member states insofar as their presence within the EU is concerned. Yet they also are the cornerstone of a body of law that grants rights directly to citizens, rights that are outright supranational, such as the freedoms of movement and establishment, incorporated in the European citizenship. And therein lies a paradox that contributes to the EU's peculiar nature. Even though European law applies directly to citizens, and may therefore be considered a distinct category of constitutional order, the treaties essentially are interstate agreements. As much is declared at the very outset of the Treaty on European Union. If the EU is the constitutional object, then the subject is the collective of the nation-states that sign and ratify the European treaties. European law may treat all citizens as European, but the overall architecture of the European Union has little scope for the instantiation of a genuine European demos. For example, European citizens do not have the power to elect their own supranational executive. The European Commission's political leadership is essentially determined at an intergovernmental level, subject to approval by the European Parliament. Similarly, the President of the European Council has no executive power in their own right, and is appointed in office by national governments. The treaties are the fundament of legality in the EU, though they obviously do not exist in a legal vacuum. The member states have constitutional traditions of their own. These are considered equal, as are nation-states qua states. Given this, and the specifics of the European treaties, it is best to speak of the EU's primary law as a functional extension of the normative achievements of European nations. The purpose of the treaties is, first and foremost, to arrive at what is common in the multitude among the national constitutional traditions, and to elevate it to the status of general rule for the entirety of the system. It is therefore no surprise that the treaties need to be ratified by every nation-state. That ensures their compliance with, and orderly continuity of, the national constitutional order. To recapitulate on the general features of the European treaties, let us recall the following. The first truth about EU primary law is that while it is the product of international relations, a covenant between nation-states, it is supranational and substantive nonetheless. The specifics of European law are what distinguish the European Union from international organizations, and what make this architecture a federal system that resembles a federal republic in several important ways. The second truth about the European treaties is that they are complementary to the constitutional achievements of the member states. The EU does not abolish its nations and nation-states. On the contrary, it is contingent on them. The EU provides a platform and legal institutional framework for the coexistence and concerted action of its member states. European law is meant to enhance and functionally extend the normative achievements of European nations. The third truth about the Union's primary law is that it is not referred to as a constitution, due to the significations attached to that term. We still refer to the European treaties as treaties, as if they were standard tools of interstate relations. Though arguments over semantics can be made, the practical constraints are political. Citizens attach great value to a constitution, and are justified to consider it the cornerstone of a republican order. Given that the European demos is not yet fully realized, citizens are right not to consider the European treaties as a true constitution. We therefore claim that the Union's primary law is the de facto constitution of an otherwise idiosyncratic political organization. All of the above granted, let us now proceed to the principles of the Union's primary law. Though we can be descriptive and enumerative, we shall remain somewhat generic by only referring to its irreducible qualities. By that we mean to discuss those principles without which the EU would and could not exist, at least not in its current form. In this light, there are three constitutional principles, namely 1. Conferral, 2. Subsidiarity and proportionality, and 3. Delegated sovereignty. The principle of conferral is what determines the distribution of competences in the Union. It regulates relations between the supranational and the national levels. The idea is that powers that are explicitly conferred to the EU are no longer within the reach of national governments, and, conversely, any area of policy that is not mentioned in the treaties remains a national prerogative. The distribution of competences is based on an exhaustive list that follows a threefold qualification. A. Those competencies that are exclusive to the Union. B. Those that are matters of shared competence between the EU and the Member States. And C. Those where the EU can only be supportive of the operations of national governments. We can better understand this qualification as a spectrum of power distribution. Exclusive competencies confer sovereignty to the EU institutions. The supranational level has the first and final say. Shared competence makes sovereign authority a matter of supranational and intergovernmental deliberations. In this case, no national government can act on its own accord, nor can its initiatives prejudice the actions of the rest of the Union. As for the supportive competencies of the EU, they leave authority to the national level, though the Union can still issue its recommendations and, perhaps, exert a degree of diplomatic pressure when and where necessary. Subsidiarity and proportionality. Though subsidiarity and proportionality can be treated as distinct principles based on their function, they do in fact apply to the same issue and pursue a common objective, namely, the method by which the distribution of competences among the various levels of governments is to be achieved. Subsidiarity and proportionality are hereby considered connatural by virtue of their common telos. Subsidiarity is the idea that authority should be exercised at the appropriate level of governance, following an ascending direction, from closest to the citizen to furthest. If a certain issue can be fully addressed at the local level, then only the local authorities should have power over it. Phenomena of national reach are best treated by the central government, while those with a cross-border or global scope lend themselves to political action at the supranational level. For this bottom-up approach to be limited to the sought ends, proportionality is needed. Powers trusted to an authority should always be commensurate with the task at hand. Thus, even if, say, the EU institutions were supposed to act on a given issue, their policies should in no way grant them additional powers, and should not prejudice the capacity of other levels of government to adapt as necessary within their remit. Subsidiarity and proportionality substantiate a method for limiting the power of the state, and for enabling citizens to place a check on the government, not least via the judicial route. Delegated sovereignty. For a nation-state to become part of the European Union, it has to comply with the community acquis. In other words, it has to transpose into national legislation the rules and legal provisions that form the acquired level of European integration, and make sure that its constitutional order is in harmony with that of the Union. Put simply, EU member states agreed to divide their sovereignty and transfer a significant portion of it to the supranational level. It is important to note that the nation-state that is granted membership to the European Union does not forfeit its claims on sovereignty. It rather offers its consent to a redistribution of authority along functional lines, of it being necessary for the proper operation of the EU. This idea is reflected in the European treaties, which provide for the possibility of a nation-state reclaiming its sovereignty and thus exiting the Union as a result. Full national sovereignty and EU membership are mutually incompatible. Though the treaties do recognize that nation-states do not forego their claims on sovereignty, they do not allow the bond formed between the Union and the member state in question to be terminated unilaterally. Any member state willing to repatriate sovereign authority must engage in negotiations with the rest of the Union, and must gain their approval prior to exiting. In practice, this means that a series of negotiations need to take place, which will most likely conclude in a compromise agreement. This is exactly what is happening with the United Kingdom. We have so far made the argument for understanding the European Union as a constitutional order. We also noted that we still consider it to be a federal system rather than a federal republic. These two positions may seem contradictory. The notions of constitution and republic tend to be intimately linked. A democracy must be based on a clear set of rules, typically in the form of a codified corpus of primary law. The purpose of such fundamental laws is to identify, and then safeguard, the goods that the polity considers common to all its citizens. The protection of the public good, or else the res publica, is at the heart of what a constitution does. The perceived tension between the thesis of the EU as a constitutional order and of the EU as a federal system can be upheld simultaneously by appealing to a third element, the res publica, and the fact that it is not fully realized at the supranational level. Put differently, our argument for the EU as a federal system rather than a federal republic is based on the idea that it still lacks a genuinely European public good. The EU is a republic in the making. European integration is a process that may eventually lead to the establishment of a European democracy. The present architecture has the potential of delivering on the public goods peculiar to a republic. It still falls short of actualizing that promise. What are some of the goods that constitute the res publica? A narrow reading would include the following: representative democracy, division of powers, rule of law, secularism, delineation between private and public goods, a social market economy, the sovereignty and independence of the state, based on the self-determination of its people. A more comprehensive view of the res publica would add another set of items, such as freedom of speech and media pluralism, protection of human rights, respect for the rights of minorities, equality between people regardless of their education, social background, beliefs, sexual orientation, protection of the environment and the species. The EU does, more or less, satisfy all of the above. In particular, it features the division of powers as per the operational independence of each of its institutions, the rule of law, the applicable principle of limited government, and the respect for the rulings of the courts, secularism, multiculturalism, multilingualism, representative democracy, however, with the European Parliament being the only institution that enjoys direct input legitimacy, social market economy, that has nevertheless been brought under extreme pressures throughout the years of the euro crisis, practical sovereignty manifesting in the primacy of supranational acts on issues where the Union maintains exclusive competence, the international independence of the EU as well as the concerted self-determination of its peoples through the ratification of the European treaties, a comprehensive range of core values which may be broadly covered by the ideals of pluralism, environmentalism, and humanism. If the EU conforms with the republican model, in what sense may it be considered a republic manquée, a republic that has yet to be fulfilled? Where the European Union deviates from the generic understanding of the republic is in the specifics. As we noted before, there is no fully realized European demos, not least because citizens do not have the power to directly elect the supranational executive, the EU government. The European Commission, which is the system's implementing executive, is a political body in technocratic clothing. It is led by a group of commissioners, one per member state, who are in fact appointed in office following a grand intergovernmental bargain, even though the European Parliament continues to entertain the largely exaggerated notion that it has actually elected the Commission President, Mr. Jean-Claude Juncker, via the Spitzenkandidaten procedure. Furthermore, the Commission's role is supposed to be purely technical in nature, to initiate the legislative process, to implement supranational acts, and to monitor the compliance of member states with the Union's legal order, to be the guardian of the treaties. In spite of its technocratic mandate, it is headed by a college of commissioners that are prolific politicians in their own right, and who are in office courtesy of a political agreement. The political nature of the European Commission hampers its technocratic purpose. It renders it prone to external pressures, political calculations, and ulterior motives for gaining leverage in the political process. The other institution of the European Union that qualifies as an executive is the European Council. It is where the heads of state or government meet to deliberate on the future of the European integration process. The European Council is the entity that instructs the Commission to pursue whatever policy agenda it is pursuing. For example, the recent agreement between the EU and Turkey was made at the level of the European Council. All of the adopted decisions are to be implemented by the Commission. To that end, the Commission may also have to initiate the ordinary legislative procedure. Here, too, European citizens, the demos at large, cannot have a direct input on who gets to be the Union's deciding executive. The formation is intergovernmental, which means that all agreements are a compromise between competing national interests, without the European interest as such being represented. European citizens do not know exactly what transpires at the European Council summit. Everything happens behind closed doors. This practically means that the demos cannot exercise its duty of scrutinizing the authorities. It cannot place a check on those who adopt decisions on its behalf. It is readily apparent that when it comes to the executive function, the direct input legitimacy of the EU leaves much to be desired. In this regard, the brand of representative democracy that exists at the supranational level is actually inferior to what applies, at least in principle, at the national level. The other area where the EU falls short is social and civic policy. European integration is a rather uneven process. There exists a single market, an extensive framework for economic governance, a monetary and banking union. But there are no such things as a proper supranational unemployment scheme, supranational pension funds and social insurance, outright European legal persons, such as associations and non-profit organizations, an EU-level fiscal policy, which would include, among others, European taxation and the European investment policy. On such issues, the EU is nowhere near as competent as the nation-states it encompasses. Though citizens may benefit from the equivalent national public goods, Their life becomes much more complicated when they engage in cross-border activities, activities that are supposed to be the quintessence of European integration. At any rate, our concern here is the supranational level as such. We examined its primary law and found that it does qualify as a constitution. We have compared some of the main features of the EU with the Republican model and discovered that it does indeed conform with it. Where we identify flaws is in the substantiation of a genuinely European res publica, both in the form of an actualized European demos and in the institution of supranational public goods. It is for those reasons that we conclude the present seminar with the realization that the European Union is a polity that can be described by its three main characteristics. 1. Its primary law, the European treaties, is a de facto constitution. 2. Though the EU derives from interstate covenants, it is not an international organization, but rather stands as a federal system, a hybrid of a federal republic and a confederation. 3. The supranational level satisfies several criteria of the republican model, but falls short on a number of specific issues, thus making the European Union a republic manquée.